Hi, and welcome to Module 6, Employee Rights. The term for the day is Pall of Orthodoxy. Now, the word pall, P-A-L-L, refers to a feeling or a culture that overspreads or shrouds something, including organizations. And orthodoxy is a set of beliefs. So when you put the two together, Pall of Orthodoxy occurs when a culture has developed within a school that allows only one belief system to be valued, heard, or represented. Now, courts really frown on this. They want schools to be open and neutral to multiple viewpoints. So as I go through the video, I'll point out an example of how Pall of Orthodoxy could come into play in school law. So, as you know, this module is about employee rights, and you've probably noticed in your assigned chapters that it's true that employees have fewer rights than students. Now remember, that doesn't mean they have less authority, but as representatives of the state, their rights are somewhat limited. Their rights as citizens, however, still fall under the First Amendment, so it's always an interesting line for school administrators, right, and school leaders to discern when they can limit rights of their school employees and when they can't. So here are a few examples on different topics that fall under employee rights that you may encounter as a school leader. First, there's the issue of academic freedom. Now, at the university level, academic freedom is a very big issue, but for teachers in pre-K-12 settings, it's not so much the case. Teachers are really limited to their prescribed curriculum. They have to keep their personal viewpoints out. They have to be neutral, right? And they have to align to what they're talking about to the standards. And it has to be neutral points of view. So in most cases, teachers don't have a good opportunity to bring a lawsuit that says my academic freedom rights have been violated. In order to win in a court case, to show that your academic rights have been violated, they'd have to prove that their speech was so limited because a pall of orthodoxy was prevalent in their school, which limited teachers from any form of freedom of expression. So, let's talk about freedom of expression specifically. One issue that's always a little bit interesting is whether teachers can speak out on matters of public concern. Now, they can speak out about things that are going on at the school as long as they do it with the intent of just giving information and is for the betterment of the group. They could say, for example, if a parent asks them a question, they can give facts and explain a perspective, right? But when the courts say that a teacher's freedom of speech is limited here is when a personal interest in bringing up a particular perspective is present. So if, for example, a school district's going to lay off teachers, and a particular teacher starts writing letters to the editors saying, this is unfair, it's not right, they're not using their money correctly, etc. Well, wait a minute, they might have a personal interest, meaning they're going to be one of the layoffs. So the courts are going to weigh whether or not a person is speaking out professionally on a matter of public concern or whether they're speaking out personally. And if they're speaking about something that affects them personally, they do not have the freedom of expression of rights. Freedom of expression rights, sorry. Here are a few other ways that teachers have set limits on how they may speak. So let's take the case of politics. Teachers really have to remain neutral at school related to their political viewpoints. Now, as a person, they can go out and work after work and campaign for their favorite politician. They can even go door to door and work for a campaign. But one thing they can never do is say they're speaking on behalf of the school. So they might go door to door and ask somebody to vote for their favorite candidate, but they can't say vote on behalf of the school district, right? Because they're speaking personally and not professionally. Also, remember that they can't use school supplies. I've had cases where teachers are making copies of flyers for church bulletins or politicians, things like that, and they're using school supplies. That's not okay because these are state resources, and they can't be used for a particular viewpoint or a religious perspective, right? So these same concepts apply to religion. And of course, a teacher can express their religious beliefs outside of school. They can belong to any church. They can do all the things related to their faith. But once they walk in the door, they're a representative of the state, and they must remain neutral and open to all viewpoints. So I think that the interesting thing that I hope you're seeing in law now is that we started with student rights, and some of those crossed over with teachers, and now we're looking at employee rights, and these concepts should be sounding familiar. So hopefully you're thinking, okay, this makes sense. We've already gone over this topic. So I just want you to pick up on these patterns, that there's patterns in law related to education, and that as an educational leader, you can rely on these patterns to make decisions. So let's talk about inappropriate use of language. As you know, teachers don't have the right to use offensive language or to use language that promotes hatred or illegal activity in front of their students or their colleagues. Courts have ruled that teachers don't have the right to use the kind of speech that kind of speech, and that they can have disciplinary action taken against them if they continue to do so. Remember that if a teacher is seen as unfit or unprofitable to the school, and if the school can make the case, they do have the right to move them from that teaching position. Now, of course, there's all kinds of due process that would come into play, and we'll talk more about that the next module. But it's important to know that teacher speech can be regulated to some degree. One thing that I think that we don't help our teachers understand enough is the impact of social media. Many districts have policies such as they say teachers can't friend students and that they need to be professional and careful and personal with their Facebook or their social media, whatever site they're using. And we stress that to undergraduate students, right, not to have a Facebook open for anyone, because just anyone to see, because employees are going to check it, and if they're doing an illegal activity or engaged in something that would seem unprofitable to the culture of the school or makes them appear unfit, that they won't get the job or they may not get the job, and it may affect future employment as well. So social media is really a growing topic in school law, and I think we're going to hear more and more lawsuits from both sides of educational leaders taking actions and then maybe teachers pushing back. But for now, the courts have been really clear that with schools, if they find that a teacher's behavior in almost any setting really doesn't reflect well on the school, and they can make a strong enough case that they're going to be supported in removing that teacher. In a recent case, I think it was a police officer, did this rant on white supremacy on his page, and it was a closed group, but somebody took a picture of it and then sent it to the police chief, if it was the police officer. And he lost his job. And he sued in court because he said it was a closed group, it wasn't open to the public. And the judge said, yes, but this is a really good example of how it doesn't matter if it was a closed group. Once it's out there, it's out there. And now you're seen as unfit. So be really careful. Okay, you've read a little bit about dress code, and typically cases against dress code, as long as it's reasonable and it's applied even-handedly across the board, courts will uphold the rights or have upheld the rights of schools to have a dress code for their employees. And usually, if you were taken to court, they would ask you to provide an educational interest in having a dress code policy, but it's usually pretty easy for schools to do that. So unless the dress code is overly officious or, requires something that could really can't be justified from an educational standpoint, for the most part, teachers are required to comply. So let's talk a little bit about privacy. This rule, the rule is going to match a little bit what you've already learned about students' rights and privacy. So teachers have an expectation of privacy just like students do in school. The privacy right does extend to their personal lifestyle choices, which includes with whom they live, with whom they associate and affiliate, all kinds of things, as long as it's not illegal or doing something that's so egregious that it would reflect poorly on the school. So most of the time, school districts don't have any business interfering with somebody's personal life, their relationship, who they're carrying out the relationship with. So in other words, I guess my best advice to you would be to stay out of teachers' personal lives as much as you can. Let them be private citizens in their own right, unless something is just way, way out of bounds in terms of legality. Now, while they're at school, of course, they're supposed to be acting professionally, and this includes all facets of their work, including their personal school email, right, on a school computer. And so I want you to think about, if you have a suspicion the teacher is using a computer to go to porn sites, I actually had that, or is emailing students inappropriately, you do have the right to search that equipment because, like with students, it's a school equipment and you have a reasonable suspicion. The equipment's owned by the school, so you can look at their email. And courts have upheld the rights of districts to read emails on computers and to look in their classrooms. But a search would not be justified of their own personal belongings like their cell phone or their purse or bags or anything like that in a case like that. So just kind of like with students where there's a reasonable expectation of privacy, the same thing where I own my things, there's a reasonable expectation of privacy. Okay? But it's a little less so on school-owned things for adults than students. Remember that you should only search when you think a teacher's been doing something that's work-related, and in order for you to search, like if they're using a school computer, they're not doing something appropriate, then if you have reasonable suspicion, you can. So if it's work-related malfeasance, you have the right to search. If it's something, again, like maybe the sheriff comes in and says, we have reason to believe that a teacher, something's going on with this teacher, they have to have a warrant to search. So I advise you again, don't get involved with situations with the police, right? Of course you want to be on good terms and support the police, but they have rules for what they can search, and you have rules for what you can search, right? So keep that in mind. Great. I look forward to further conversations.